while I can't say as I understand the struggles that the defendant is going through, I do emphasize, have empathy for those struggles. Person at the jail, what is your name?
William Horton.
This is case number 25714FY, the people of the state of Michigan versus William Dane Horton Jr. Mr. Horton, you are here for a probation violation. It is alleged in count number 1 that you committed the following technical violation: that you tested positive for methamphetamine on August 4th, 2025. If you are found to be in violation of that term of your probation, you could be sentenced to what you could have been sentenced to under the original plea, which was to use of methamphetamine, which is a 1-year misdemeanor. Additionally, because you are sentenced under 7411, you could have that 7411 protection revoked and your conviction enter on your public record. Do you understand that?
Not really.
All right. Let me try to explain it again. So if you are found to be in violation of probation, you could be sentenced to what you could have been sentenced to under the plea that you had to use of methamphetamine. So you could be sentenced to up to a year in jail. Do you understand that?
Yes, sir.
Also, you were sentenced under 7411, which is the diversion provision of the statute. So if you were successful with your probation, the charge would not appear on your public record and it would be dismissed. However, if you are found in violation of your probation, the court could revoke that 7411 protection, which would allow the conviction to appear on your public record. Does that make sense?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to pay a portion of that expense.
Yes, sir.
Today, are you requesting the appointment of an attorney?
I think I have one for right now, but I don't know who he is yet.
Well, they probably just met with you for arraignment purposes, but if you want the court to appoint one, we can go ahead and have that happen. So are you requesting the appointment of an attorney?
Yes, sir.
All right, the court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea on your behalf. Well, I guess let me back up. We'll make the appointment of an attorney. You also have the right to have a bond entered. Bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I show in 08 and operating while intoxicated, and he was just placed on probation back on May 6th. Ms. Edgemere, have you had the opportunity to speak with Mr. Horton about this case?
Yes, Your Honor. I wasn't aware of some of the probation conditions when I went to meet with him, obviously, so I haven't had, a thorough conversation with him. I wouldn't say that I have talked to him.
Did you talk to him about the possibility of having a hearing or set it for a contested hearing? And we have some time. Do you want to talk with him about some of the allegations you learned today, or?
Would you mind if I talked to him just about the 7411 part of that? And
yeah, like I said, this is the only arraignment today, so we have some time. So if you want to get on Zoom, Mr. Horton, I'm going to place you and the public defender in a breakout room so you can chat about the allegations. All right?
Yes, sir.
Mr. Horton, are you able to see and hear the courtroom again?
Yes, sir.
All right, we are back on the record in case number 25714FY. Ms. Edgemere, have you had the opportunity to meet with Mr. Horton?
yes, sir.
And what is our plan of attack today?
Mr. Horton plans to plead guilty to the alleged probation violation.
Is that accurate, Mr. Horton?
Yes, sir.
All right, will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Mr. Horton, is it true that the court placed you back on probation on May 6th of this year?
Yes, sir.
And as a term of probation, you were not to use any illegal drugs. Is that correct?
Yes, sir.
Then to the allegation that you tested positive for methamphetamine on August 4th, 2025, how do you plead?
Guilty.
In order to accept that plea, I must have you tell me a couple of things. First of all, has anybody promised you or threatened you in any way in order to get you to plea today?
No, sir.
And is it your own free choice to plea?
Yes, sir.
Are counsel aware of any other promises, threats, or inducements that have not been made part of the record in which to entice the defendant to plea?
No, Your Honor.
No, Your Honor.
Then, Mr. Horton, back on August 4th of 2025, did you test positive for methamphetamine?
Yes, sir.
Is that because you had ingested methamphetamine?
Yes, sir.
And did you know it to be methamphetamine?
Yes, sir.
And you knew that was against your probation terms, is that correct?
Yes, sir.
And you had no lawful reason to ingest the methamphetamine?
Say that again.
You had no lawful reason to ingest the methamphetamine, for example, it wasn't a prescription or anything like that?
No, sir.
All right. Do counsel believe the defendant has provided a factual basis to accept the plea and that the court rule has been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court. I find the plea is knowing, voluntary, and accurate. Mr. Horton, I find you guilty of one technical violation of violating probation by testing positive for methamphetamine on August 4th. Ms. Bismack, do you have a recommendation?
I do not, Your Honor, since this was just the arraignment, I had not gotten to it, but verbally, I would recommend the removal of the 7411 and 5 days jail with 1 credit.
We show 2 days credit.
1 day on the PD, 1 and
2 total, 1 on the
2
PV.
total. Yeah,
right.
1 on the PD. Yeah.
All right. And continue probation, I assume?
And continue probation.
Ms. Ejimera, any elocution?
Yes, Your Honor. I'd like to start by saying, Mr. Horton is a disabled veteran. He lives in there, he's lived in there for his whole life. He certainly made a mistake. He did have a couple of months there where he was doing relatively well in probation. I would say no violations, this is his first violation. So I would ask that, the court take into consideration the struggles that Mr. Horton has as a disabled veteran. He's got PTSD, sleep apnea, his knees bad, he's in pain, and that's not an excuse to do drugs, but it is. I would ask that the court take it into consideration, and that he is struggling in many aspects of his life, not just in attempting to beat this addiction, which is obviously a difficulty. I would ask that the court consider continuing him on probation and maintaining 7411 status, and allow him to have a second chance. I think that he will make good use of that second chance if given the opportunity. Thank you.
Thank you. Ms. Laura?
Underlying charge that the defendant pled to was use of methamphetamine. He was sentenced back in May, so he really has not been on probation that long, and he's already violating. Given that, the people would support Ms. Bismack's recommendation.
Ms. Bismack, I know a condition of the plea was that he was to do inpatient treatment. Can you, I think at least 30 days. Can you bring me up to speed on that?
He had enrolled with the VA into residential treatment back on 6/23. He was discharged due to some program violations back on July 9th. I've spoken with Heather from the VA, and William is set up for a mental health evaluation August 21st in Traverse City. We would like for him to get that completed, set him up with some outpatient. Once he starts that ball rolling, the VA is willing to have him come back to rehab inpatient and finish his time out there.
How long was he in treatment then?
It's less than a month he was there.
Thank you. Mr. Horton, you do have the right to address the court prior to sentencing. Is there anything you would like me to know?
No, sir.
Well, like I said before, historically, the only thing I show is operating while intoxicated from '08. There is another assaultive crime that I can't necessarily tell the disposition on, so I'm not going to take that into account. I do believe the 5 days is appropriate. I believe that that is what the court is bound by, given that this is a first technical violation. So I will impose 5 days jail with a total of 2 days credit. That leaves the court with the question of what to do regarding the 7411. While I can't say as I understand the struggles that the defendant is going through, I do emphasize, have empathy for those struggles. However, I think it would have weighed a lot more with keeping 7411 had he completed the treatment program as opposed to being discharged for program violations. So the court will continue the defendant on probation, but I am revoking the 7411. And again, 5 days jail with 5 days credit. I'm sorry, 2 days credit. That's what happens again when I try to speak and write at the same time. 2 days credit, 5 days jail, 2 days credit. Anything else, Ms. Bismack?
No, Your Honor, thank you.
Ms. Lawrence?
No, Your Honor, thank you.
Ms. Edgemera?
No, Your Honor.
Mr. Horton, good luck to you in the future, sir.
Thank you, sir.
Thank you, jail.
Thank you, Your Honor.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.